Mr. Chairman, Ranking Member Blumenthal, thank you for this opportunity to testify in support of S 3042, the Justice for Service Members Act, and to share my personal views and experiences on the importance of strong USERRA law. I applaud Senator Blumenthal for introducing this much-needed legislation that would clarify that service members and veterans cannot waive their substantive or procedural rights under USERRA, consistent with the original intent of Congress when it enacted USERRA in 1994. As a private citizen, a combat veteran, and reservist, I stand with the 32 veteran service organizations in the military coalition who support this legislation. Without USERRA's strong substantive and procedural protections, it would be impossible for millions of Americans to serve in the Guard and Reserves to help protect our homeland and advance America's interests abroad. As the committee is aware, USERRA guarantees service members their right to return from their civilian jobs after serving in the military and prohibits employment discrimination based on military service or status. USERRA makes it possible for reservists like me to serve our nation in the armed forces. Several years ago, I lost a job that I loved because I chose to serve my country. But sadly, my story is not unique. Each year, thousands of reservists lose their jobs or miss out on benefits because employers are not aware of USERRA or they find our military service to be inconvenient. In July 2010, I was hired by a federal contractor called BLB Resources. From 2010 to 2012, as a manager, I helped BLB expand its operations and workforce from 18 employees to over 90. In November 2012, I received active duty orders to deploy to Afghanistan for 12 months. As soon as I learned of the upcoming deployment, I gave BLB notice. On my last day of work, BLB hosted a lunchtime party to honor my military service. 40 co-workers gave me a standing ovation. I was presented with a large cake with an American flag and the inscription, "Best wishes, Kevin," and my colleagues decorated my office with camouflage netting, along with cards and gifts that were stacked on my desk. Around 4:45 on that same afternoon, I was called into the Human Resources Department, where I was promptly fired and told that my position would not be available upon my return from active duty. I was shocked to learn that I was being terminated from my job on the eve of my deployment to a combat zone. It created an unimaginable amount of concern and anxiety about how I would earn a living once my military orders had ended. Upon returning home from Afghanistan in 2014, I was further surprised by what happened when I tried to enforce my rights. After I filed a USERRA claim in federal court, BLB asked the court to compel me to arbitrate my USERRA case, and the court agreed. This was shocking because I knew that when Congress passed USERRA, it explicitly stated that veterans and service members could not waive any of their rights, that they are entitled to enforce their rights in federal court, and that they cannot be required to arbitrate their claim. Fortunately, my story did not end there. I found legal advocates who agreed to take my case to the U.S. Court of Appeals and, if necessary, to the U.S. Supreme Court. But the nation's highest court shouldn't need to decide whether service members can waive their procedural rights under USERRA. By passing the Justice for Service Members Act now, Congress can clarify that all USERRA rights are protected against waiver and ensure once and for all that no service member is forced to choose his USERRA rights and a job that puts food on the table. Today, service members face uncertainty when they enforce their USERRA rights. In 2005, the Bush administration issued a final rule stating that service members cannot be forced to arbitrate their USERRA claims. Some courts have faithfully followed the intent of Congress on this issue, while others have not. Due to this split within the courts, it is much harder for service members to leave their civilian jobs with confidence when they are called to duty, because they don't know what to expect if they ever need to enforce their USERRA rights. When service members are required to arbitrate their USERRA claims, they don't just lose the right to file an action in court. They also lose many of the enforcement tools that make USERRA a strong law, such as the right to file in any district where the employer has a place of business, the lack of a statute of limitations period, and a ban on making service members pay filing fees or an employer's fees and costs. By enacting the Justice for Service Members Act, Congress can send a powerful bipartisan message to all those who have served or are thinking about serving in the future. Congress can make clear that it understands the challenges we face and supports us, so that no service member or veteran will ever again experience what happened to me. No warfighter who is asked to leave his job and risk his life for his country should ever need to worry about fighting for his job when he returns home. Thank you very much for your time and consideration on my views. I look forward to answering your questions.